Next, you're going to learn about the legal responsibilities and what's being developed, nationwide in terms of law, case law that's out there. We proudly want to introduce Jeff Litman, who is both a Polk County magistrate judge, and he also has a law practice in Des Moines, Iowa. Jeff is currently involved in the nation's first class action lawsuit involving bedbugs. Jeff is president of the Iowa Magistrate Judges Association, and he serves on a number of Supreme Court and Bar Association commissions and committees in that state. He's also a frequent speaker at both judicial conferences and bedbug seminars such as this. So without further ado, Jeffrey Litman.
Thank you. Thank you. How do I, this one here? Oh, okay. Again, my name is Jeff Litman, and on my presentations, I like to be as interactive as possible. So in the middle of my presentation, ask me questions. If you have something that pops up, ask me. If you have a comment, go ahead and make it. I have a PowerPoint, but I'm not married to the PowerPoint, so I could adjust it depending on what your interests are, what your concerns are. So feel free to pop in questions as we go along. Toward the last 10 minutes of the presentation, I will kind of run through some damage calculations, kind of show you a model of what you're looking at if you do not do the things that you need to do to protect yourself from bedbug litigation. Now, the first thing I want to talk about is that for pest control operators are at risk of being named in lawsuits, so it's important for them to document their action plans and their alternatives in writing. Now, hotel and motel and apartment managers will be named in lawsuits. So it's important that you have a written action plan that's given to you by a pest control operator and have a written engagement contract specifying that you are hiring them for bedbug maintenance and eradication. Now, this is very important. The first one is that you have to contact. If you're in a hotel, how many people here are in the hotel business or motel business? How many people here are in the apartment renting business? Okay. It is extremely important, I'm going to say this time and time again, is you need to employ a pest control operator. Even if you've never had a bed bug in your apartment or hotel, you need to have somebody on contract immediately to begin monitoring and educating your staff on how to find and how to spot bed bugs. And it's important that when you do that you have a contract with the PCO or the pest control operator that give you the education and a written action plan on how you are going to monitor, how you are going to train and treat bed bugs when they come along. And you want to have in your written engagement plans, you have a lot of pest control operators have general pest control engagement contracts. This one needs to specify bed bugs. And if it doesn't, you better write it in. But I'll tell you, if you don't have a PCO that has something that specifies bed bugs, get a different PCO. There's a lot of PCOs out there. I've heard somewhere in the neighborhood of 12,000 PCOs. Maybe 4,000 of them know what they're doing when it comes to bed bugs. So you need to be very particular and cautious about getting someone that's experienced in bed bug treatment and bed bug monitoring. Again, it's important that when you have a PCO, you have to have that company provide requirements for treatment and readiness. Now, this is extremely important. You always need to make sure that the tenants are ready for the treatments, and you have to have written post-treatment follow-up plans. Now, why that's important is that when you see a treatment list, especially if it's something other than heat, it is lengthy and it's difficult for tenants to get prepared for treatment. I mean, a lot of times you're going to have tenants that are elderly, that are disabled, tenants that aren't really able to prepare themselves for treatment. And the question is, whose responsibility is it? It's your responsibility. It's your responsibility to prepare those tenants for treatment or have them prepared. And if they can't do it, you need to find someone to help them out. Now, landlords and hotels have a duty to provide what's called a habitable premises. And what you need to do is that means you need to protect against clear and present dangers. And a clear and present danger has been defined under the law as conduct which presents an immediate and serious danger to safety of other tenants or the landlord. That would obviously include bed bugs. Now, the landlord must do certain things, has certain obligations. One is warn guests of the dangers of bed bugs, which means if you have bed bugs, if you've had them in your apartment, you've had them in your hotel, guests have a duty to know, and you need to warn them that you've had this discovery of bed bugs on your property. The next thing, which may be surprising, we talked about that you have to get tenants ready and help them get ready for treatment, but tenants also have a responsibility to cooperate with the landlord. And this is important because if you have tenant in one of your units who is saying, I'm not letting this PCO in to treat my apartment, that tenant is creating a clear and present danger to other tenants. Because if he has bed bugs in his apartment and that PCO isn't able to treat that apartment, those bed bugs are going to find their way into the adjoining or the adjacent apartments, the apartments up above them and the apartments below them. So what do? You need to start eviction proceedings. You need to give them the notices. You need to do what you can to remove that tenant from the premises because he is creating a clear and present danger to other tenants, and by the landlord failing to act, the landlord is thereby creating a clear and present danger to other tenants. So you need to be, you had a question.
I have a question with that, evicting tenants. Do you know of any, in your personal experience, or any existing case law, of any landlords evicting tenants and being successful?
I can tell you that...
did everyone hear that question? Just want to make sure.
Okay. Okay, the question is do I know of any specific case in a bedbug context where a landlord has been successful in evicting a tenant for a clear and present danger for not cooperating in a treatment? Is that the question? I don't know of any reported cases. The problem that you have with finding an actual reported case is that in order for there to be a reported case, it has to go through a trial, it has to go through an appeal. And a lot of these are in housing courts or magistrate courts or municipal courts. And those appeals go to the district court, then they go to the Court of Appeals, then they go to the Supreme Court. And until you get to the Court of Appeals or Supreme Court, in most cases, you don't get a published opinion. And generally speaking, these cases never make it that far. They're resolved at the lower court levels, and you never get a written decision. So you're not going to find probably any reported decisions that uphold a clear and present danger for failing to comply with the bedbug treatment. And the other reality is that this is a new and evolving issue. Now, in terms of clear and present danger, those are on the books. I mean, if you're a hotel, or not a hotel, but an apartment manager, you're well aware that you can evict tenants who create clear and present danger. And clearly, someone who is not cooperating with basically a clear and present danger to eradicate it is causing a clear and present danger. And if the landlord doesn't take action and they get sued, the first thing the plaintiff's attorney is going to say is, well, you knew you had the bed bugs. You knew that this apartment was suspected to have bed bugs. This guy wasn't cooperating. What did you do about it? Now, if you say, well, we took every step, we gave him a notice, we tried to evict him, or we did evict him, you've done what you can. But if you say, well, what are we supposed to do? Well, the attorney on the other side is going to say, evict them. So you need to be responsible and act reasonable. So I would say that the laws are already on the books. The clear and present danger provisions are already in your state statute, and you need to avail yourself of that. And again, with that, is you need to assist tenants who are mobility impaired with preparation for treatment, which means that if you have disabled tenants, you have elderly tenants, the responsibility is on the landlord. Now, I know that some of you will have service providers that come in. That's great. If they can assist the tenants with that's fantastic. And ultimately, it's the landlord's responsibility to make sure that those units are prepared for treatment, because if they're not, the PCO is going to leave. And the PCO is going to have a little piece of paper that he's going to write on, apartment was not prepared for treatment and left. And if something happens where that infestation spreads, the first thing the plaintiff's lawyer is going to do is he's going to subpoena the records from the pest control operator. Trust me, that's what I did. And miraculously, the PCOs are just renowned for being detailed in how they document what they do and whether their clients have been prepared and compliant with those treatment requirements. I mean, because the PCOs are at risk of being sued too, so they have to have good documentation. So If the documentation says we went to that apartment complex and the tenants weren't prepared, we had to leave, we weren't able to treat that day, that's going to reflect poorly on you, and that's going to open you up to liability. Now, it's important that you have ongoing investigations, which means use bed bug monitors, which are inexpensive, and periodic inspections as recommended by the pest control operator. For instance, you basically need to talk to your PCO, depending on the nature of your complex, how many units you have, how often you flip those units is going to really depend on what investigation is reasonable. And we're going to get into this a lot more. The idea here is you need to act responsibly and reasonably. You don't have to be Superman and incur a lot of unnecessary expenses, but at least you need to be trained to know how to spot bed bugs. You had a question?
Yes. What is bed bug monitoring? What does that mean?
Well, there's bed bug monitors, and there's things that you could put under the bedpost, for instance, to see if bed bugs are there. The pest control operator can tell you what's the best monitor, what's the best device to spot bed bugs, and you really need to talk to your PCO and figure out what's appropriate in the circumstances. But the important thing is that in order to be protected from liability, from being protected from being sued, you need to follow to the letter whatever recommendations your pest control operator gives you. And you need to document that. You need to keep a little journal, a little notebook. When you flip an apartment, if your PCO says, here's the checklist you go through, your maintenance people should be checking off everything on that checklist when they look for bed bugs. If he says every 2 weeks you go through the hallways and you do this type of inspection, have a little checklist and a little notebook and make sure that you keep it in a binder so that if something happens and you do get sued, you can say, hey, we did everything we could to be reasonable. We followed every piece of advice of our PCO. As a matter of fact, we had a PCO on contract before we even knew that we had bed bugs. And if you're doing that, you're going to be protected somewhat from liability to a large extent. If you don't do that, you're exposing yourself to liability. Now, you had a question?
I'd like 2 slides if you don't mind.
Okay.
Can you clarify in one place?
Sure. As we've heard in some other, I think it was in the one that we had about legislation, that there's even legislation on the books in certain areas where if you had bed bugs in your apartment complex in the past, you have a duty to warn. Now that's actually a statute or an ordinance that has mandated that. I pose to you that you have a common law duty to warn guests. If you have had bed bugs in your apartment or you have bed bugs in your hotel, I believe that you need to make a disclosure to people saying that we have had bed bugs here. Now, you don't have to say, warning, do not sleep here, we've had bed bugs, or do not come to my apartment, we're infested. But I think that a disclosure saying that bed bugs are prominent in this area, we have had bed bugs, spotted in our complex. We have a pest control operator on contract and who is, has treated this problem. And I think that if it's happened within the last 6 months, the last year, it's a good idea to make a disclosure. We're going to go into why that is and some of the laws that come into play. If you don't make that disclosure, you suscept yourself to exposure for things such as unfair deceptive acts and practices, or the UDAP statute, consumer fraud statutes, which balloon the type of damages that a tenant can get for renting a place where you haven't disclosed and then they do find that they have bed bugs. The first cause of action that you need to know about on how plaintiffs or tenants or consumers might come at you is under a premises liability cause of action. Now, it's important to know that although most states have not enacted specific laws that specifically deal with bed bugs, there are laws that are already there, common laws and laws on the books that protect consumers and give them rights of action for bed bugs. Now, premises liability is the same type of liability as a tenant might sue you for a slip and fall case, or a sinkhole, or a pothole, or a stairwell that collapses. The same cause of action that protects consumers for those rights of actions protects consumers in bed bug cases. And basically, the courts have narrowed this down to basically a 7-factor approach on how they analyze whether or not there's a premises liability cause of action. The first one is the courts look at what is the foreseeability or the possibility of harm. Basically, they look at something as, basically what is the possibility of harm that you have for bed bugs? What type of notice have you had for bed bugs? And again, what type of inspection have you done for bed bugs? What is the foreseeability that someone may be affected in your area even by bed bugs? The next factor they look at is the purpose for which the entrant entered the premises. Now, in a tenant, in an apartment complex or a hotel situation, they're there to live. They're there to sleep. If someone walks by a store, they're there to shop. If someone's walking down the sidewalk, they're there to travel. But probably the most intimate type of relationship that a consumer has with a merchant is where they live. So that is going to heighten the sense of scrutiny or the heightened sense of awareness that the landlord must have, and it's going to increase the scrutiny on the landlord because the purpose for which the entrant entered the premises is so heightened because of the nature of why they're there. The next one is the time, manner, and circumstances under which the entrant entered the premises. Again, they're there to live. It goes back with, again, it's the most intimate. The sanctity of the home is probably to most courts the most important aspect of somebody's life. Again, the use to which the premises are put, it's being used as their home. They work there, they live there. This is where they relax. This is where they spend their life. The next factor they look at is the reasonableness of the inspection, repair, or warning. Again, it goes back. Have you been proactive in your inspection? Even before you knew that there were bed bugs. Once you knew about bed bugs, what was your reaction? Was it prompt action? Was it a reasonable response? Did you contact your pest control operator, assuming that you already had one on contract? If you didn't, did you immediately contact someone? And I think they're going to start looking at who did you contact. Did you contact the first name on the books, someone that wasn't equipped to handle the problem, or did you contact somebody that was responsible? I think that courts in the near future are going to start scrutinizing on which pest control operator you contact. You need to make sure that it's somebody equipped to handle the job. And again, warning. Did you, for instance, a stairwell that the railing is not attached well? Did the landlord warn the tenant that this is dangerous or slippery floor? In this case, if you knew you had an issue with bed bugs, did you warn the tenants that there was a danger of them being exposed to bed bugs? Or a new tenant? Did you warn this prospective tenant that there was the existence of bed bugs at the premises? And I pose to you, if you don't do that, this factor is going to go against you in a courtroom. And again, the sixth one is the opportunity and ease or repair of correction or giving of the warning. It's easy to warn people. Bed bugs can be eradicated. We know that heat works. Heat kills them. So, maybe 5 years ago when heat wasn't prevalent, when you didn't have the access to PCOs that had heat treatment or have the ability to get rid of these bugs, you could say, well, how do you get rid of them? They're just a pest that chemicals can't fight, or they're eating these chemicals nowadays. But I think in today's world, where the cost of treatment has come down, the cost of heat has come down, we know we can get these bugs. I pose to you that although it's maybe not inexpensive, but it's doable. And I think the burden is going to be put on somebody that leases places to live. They're going to have to spend that money and eradicate the problem. And again, the last factor looks at the burden on the landlord and or community in terms of inconvenience or cost in providing adequate protection. Again, this goes to if you're going to rent a place, if you're going to collect rents, you're going to have to furnish a habitable premises, and if it becomes infested, you have to take prompt remedial action. Let's talk a little bit about the implied warranty of habitability. In every contract, as a matter of fact, how many of you landlords have read your leases? How many of you have actually read your leases? Hopefully most of you. Okay. How many people in your lease warrants to the tenant that you're giving them habitable premises? That you're saying, we're going to give you livable premises, you're going to give us rent. How many have language to that effect in your lease? Okay, most of you. That's an express warranty of habitability. That's actually in your contract that you're expressing habitable premises. But I pose to you that even if you didn't have any of that language, even if you had an oral contract for rent, which I know you don't, but let's say you did, there's an implied warranty of habitability that flows with every one of those rental agreements. And the implied warranty of habitability is a warranty implied by law that by leasing a residential property, the lessor is promising that it is suitable to be lived in and will remain so for the duration of the lease. And courts have recognized the obligation of a landlord to provide the tenants with premises that are suitable for habitation, which goes without saying. And under this doctrine, what you're saying is that there are no basically defects in the use of that property. If somebody has bed bugs in a residential or hotel property, obviously these are major defects that affect whether or not that the property is habitable. Now, the big question is, when does liability arise? Well, a landlord is only liable for injuries resulting from a hidden or latent defect if the landlord knew or should have known of the defect. And what that does is it implies, in that is implicit, that the landlord is making a reasonable inspection at the outset, which means that if you're not proactive and you're not making an inspection to begin with to determine whether you have those bed bugs, and you're not making that inspection at the outset, you're not being reasonable, and liability could arise. Now again, and I stress this, you're not liable for having bed bugs. The law doesn't say you cannot have bed bugs. You're going to get them. I mean, if you're in the business that you're in, you're going to get bed bugs. The idea isn't whether or not you have the bed bugs. The idea is, are you making inspections to spot them? And when you do spot them, what are you doing about it? And what this liability section deals with is, first of all, taking a proactive approach to spotting the bed bugs and then taking prompt remedial action to eradicate them once the problem is spotted. If you do that and you're following the advice of your pest control operator, you're probably going to be fine. The day you depart from that, or the day that you get lazy and you don't take actions to look for the bed bugs and you don't follow the PCO's advice, you're going to end up in a courtroom and you're going to end up hit for damages. And we're going to go over later about what's insurable and what's an uninsurable loss, because not all losses that are a result of bed bugs are going to be covered by your insurance. Now, the landlord's obligation is to do only what is reasonable under the circumstances. And they look at, they look at the expenses. Now, what this means is that a landlord doesn't have to pre-treat an apartment. Okay, you don't have to be Superman. You don't have to lay phantom down in every one of your rooms in order to prophylactically treat bed bugs so they don't come into the apartment. That's not what the law requires. It doesn't require you to be superhuman or Superman. It requires you to be reasonable, which means make reasonable inspections, spend a little bit of money to hire a PCO to be on contract, to tell you what to do, to train your employees, to tell you how to protect yourself, how to spot the bed bugs, and what to do once you know about the bed bugs. It costs a little bit of money, but you don't have to spend a great deal of money at the outset. However, where there's a potential serious danger which is foreseeable, a landlord should anticipate the danger and conduct a reasonable inspection before passing possession to the tenant. Now, this last sentence in here, however, if such inspection, or if no inspection is warranted, the landlord has no such obligation. I would say about 10 years ago, when bed bugs weren't prevalent, there was probably no obligation. I mean, you don't have to inspect for every possible thing in your apartment complexes, but you know what? In today's world, where we know bed bugs are coming, the bed bugs are here, there is a duty to inspect. So this last sentence doesn't apply to today's life in the legal community.